it will continue as they pass the resolution. And my lordships, the Constituent Assembly of the J&K temporary provision was only because it was left to the discretion of the J&K Constituent Assembly to take the final decision. Now, lordships, the concurrence by the governor is not permissible under law because my lordship's concurrence affects the autonomy of the state. It's because of that reason the concurrence is to be given by the duly elected government. It cannot be the governor under the Articles 93 or 356 of the Constitution. My lordships, the Article 3 of the Constitution says, view of the state. What happened in Jharkhand? 2 years, 3 years debate. Telangana when was formed? And with regard to J&K, 356 invoked, the relevant provisions suspended, which is unknown to law. And with regard to J&K, there was consent. My lordship, I was a full-fledged state. I was having my own constitution, 1939, prior to the Indian Independence Act. And it's because of that reason, the other side of the Kashmir, which is with our neighboring country, they have right now, maybe on the papers, they have the prime minister, they have the president, they have the legislature. I'm functional democracy. I'm proud of it. I'm a nationalist. But lordship, I take liberty to share with my lordships. People make mockery of me. Is this democracy you're proud of? They have this full-fledged state. I was having within the constitution my prime minister, my Sadri Riyasat, my legislature. I'm reduced it to the UT, LG. Forget my lordship about the prime minister. 65th amendment in 65, 6th amendment in JK Constitution, when Sheikh Abdullah was in jail. The amendment was made and this nomenclature was changed. Lordship, I'm concluding. Very important, lordship, with regard to the will of the people, lordship. The will of the people is of paramount importance. Federalism, rule of law, democracy, lordship, is the soul of constitution, basic structure, held by indication and the Bharati case. Lordship, it's not mere elections democracy. It's beyond, it's vast, the functional democracy. My lordship, will of the people is of paramount importance. I'm alive of the fact, lordship, courts are not to get swayed away. I'm 1 minute only, lordship. Yes. Courts are not to get swayed away by the emotions, but lordships, here in this instant case, the will of the people, that is the Constituent Assembly of the J&K. The sentiments, aspirations, the desire of the people is intrinsic to the will of the people. That is to be looked by lordships right now. Lordships, I am concluding, but this is very important, lordship. That is the report of state autonomy, which is the will of the people. This autonomy report is by, it's A290, volume 14, your lordship, document compilation. The government has set up, your lordship, it's very important.
What is the page? PDF?
Page A290, lordship.
Can somebody give us the...
Volume 14, lordship.
1 second, give us. All right. What is the point in there?
Point is, my lordship, the state government set up a committee to examine the question of restoration of autonomy the state of Jammu and Kashmir by government order number 196. Dr. Karan Singh is the head of the chairman of this committee. There are other members. Lordship, within 1 minute or so, I will conclude. This is the aim and object of this committee. However, other states exercise the choice. Yes.
PDF 549.
Page A2.
Yes.
How other Indian states exercise their choice, how they participated in constitution framing, and in what form did they adopt it, in not our concern. This shall be referred to whatever necessary in page to follow. But it's relevant to mention here that whereas other princely states signed the instrument of accession to India and subsequently the instrument of merger, the accession of J&K state was limited only to the areas of defense, external affairs and communication. Uniquely, J&K state is the only one to have negotiated the terms of membership of the union right till the Delhi agreement. It did not accept any provision of the Constitution of India other than those agreed to the instrument of accession and retained its autonomy. Autonomy has remained since the days of accession, the heartbeat of the people of the state. State has lost all resemblance to autonomy. Its erosion is the primary cause of Kashmir discontent. Keeping this in view, Shri Narasimha Rao, the then Prime Minister of India, announced in 1995 that the Union government would be prepared to consider autonomy short of independence for Jammu and Kashmir. Mr. Devi Gowda, as Prime Minister, offered Jammu and Kashmir maximum autonomy. The assurance was incorporated in this common minimum program of the National Front government. This is very pertinent, my lordship. This is the autonomy resolution. Recommendations are there. This is by the state legislature. This is the will of the people. Lordships, Justice Sagir, a working group was constituted. One of important was headed by Justice Sagir. And the recommendation of that very committee was that the autonomy be restored to state of J&K. My lordship, J&K was having its own constitution. This is embodiment of my emotions, desire, and aspirations, the J&K constitution. My lordship provides the flag under section 144, which is made dysfunctional by the 273 CO, impugned COs. My lordship, very briefly, lordship, with regard to the which is very vital and very important.
The others who have to
Only 1 minute, lordship. That is the Delhi
said that
agreement.
about 3 minutes ago, so I think we'll conclude.
1 minute,
Thank you.
lordship. Only
No,
1 minute.
Thank you very much. Mr. Bhatt now. Mr. Bhatt, Mr. Zahur Ahmed Bhatt.
I pay lordship, keeping in with the democracy, federalism, and the self-contained provision of 370, we pray that it's not sustainable, the impugned COs. So justice be done with the people of Jammu and Kashmir, lordship.
Thank you.
Thank you.
Obliged,
Yes,
my
Mr.
lord.
Bhatt.
Lordships, I teach Indian polity to the students in Jammu and Kashmir, and it's very embracing and very difficult for me, like people like me, since 2019, when we teach this beautiful constitution and beautiful democracy, and when they will ask, are we really a democracy since post 19 August 2009, since August 19, and it's very difficult for us to answer. Basically, it was very unbelievable on 4th August 2019, when despite the assurance of Honorable Governor, then Governor, that their Article 370 will not be abrogated, in the midnight, curfews being imposed, all 3 chief ministers, cabinet
Can you
minister.
formulate your point? Just formulate the point now, because we've heard all this, almost for the. Also, I'll tell you why there are other people. Mr. Shankar Narayan has been waiting here for the last 12 days of hearing. Oh, how many days? 11? We have to give him some time. So please give us your specific point so we can leave some 20 minutes at the end. Mr. Beg has to argue for 10 minutes.
Within 2 days, 5th and 6th August, special state of Jammu and Kashmir was downgraded into 2 union territories, Union Territory of Ladakh and Union Territory of Jammu and Kashmir. These impudent actions are completely in violation to constitutional morality of Constitution of India, right to democracy and consent of the people of Jammu, Kashmir and Ladakh, procedure established under the law, national interest of this country, cooperative federalism, supremacy of constitution, rule of law. On 5th August and 6th August, Jammu and Kashmir had the legislature, which had basically the legislature of Jammu and Kashmir comprises legislative assembly and legislative council.
That point was made just this morning by Dr. Guruswamy. He has made the point.
What I'm going to tell.
Yes.
And instead
Don't repeat that, because that has already been made this morning. Just you are listening to it.
Yes, yes,
Same point has been made.
in legislative council,
Get on with something new. Tell us something new. And by Ms. Ramakrishnan also has made the same point in the morning.
I'm submitting legislative council is having 36 members, and it was not dissolved on 5th August. It was dissolved in October 2019. So it was in operation. Legislative assembly was dissolved in May 2018. So because the state legislature comprises legislative council and legislative assembly, on 5th and 6th August it was there. So if we respect the consent of the people, which is federal, this is basic structure of the constitution. So there could have been option to get any concurrence from even a recommendation for this reorganization act from state legislature, which is mandatory. So part of state legislature was that. So when we see this was ignored. This was ignored and is not highlighted as on date. That legislative council, 36 members, they were also detained. Some of them were detained, some of them were not detained.
It is already
Yes,
It is already told to us by so many people that is all 3 CMs, legislatures, they were all detained.
few were detained, few were not detained, because we don't have absolute this information. It was whole the state was under the blockade. Now, Lordships, when we go to Jammu and Kashmir State Election Act, where Proviso 3rd is suspended, so it was mandated for that. So it was there is on
All right, thank you,
proclamation.
Mr.
Very, very important submission. Proclamation dated December 2018. Dear President is knowing that this shows the intentions, because legislative, when we will get this re-election act in the parliament, there it mandates state legislature. We are here before 1 year. In proclamation, Proviso 3rd is being suspended. Coming to the Article 371, important point which I want to highlight here. One is consent of the people was not respected, which is the very beautiful and basic structure in our constitution. Article 370, basically, it was, as Goswami, this ma'am said, that it was the constitutional intention of Constituent Assembly of India and Constitutional Assembly of Jammu and Kashmir. They issued them some guarantee, and Constituent Assembly of Jammu and Kashmir made the constitution. When Jammu and Kashmir constitution is framed, then, in my opinion, the proviso subclass 3rd of Article 370 has gone. That has no scope. So
We'll wrap it up now. Thank you very much. Yes, now Mr. Beg.
with one submission at last.
Please give Mr.
With
Beg
one
a
submission at last. With one submission.
Yes.
We hope that this impugned actions, impugned orders may be cautioned, and question of 4th
Yes,
August
Mr.
may be
Beg.
restored to the state of Jammu.
Yes, Mr. Beg.
Obliged, Lord.
Second hour. बताएं उनको।
My lords, I must express my gratitude for you to give me some time. There was some misunderstanding. I had an advocate on record about a month back, and he didn't inform me that he had withdrawn. So I had to make very urgent arrangements, and the kind of assistance which this honorable court deserves. In one day, I could not really come up to that standard. My lord, before I go to the present petition, I must inform my lord that this issue had come in 1982. There was a conflict between two parties in the Legislative Assembly on whether Article 370 should be made permanent or is it only transitory, temporary, because the sideline says temporary and special provisions. 370 has 3 temporary, transitory positions. So, my lord, there is a history behind that, why it was called 370 temporary, because either because they were bound by our misfortune, our Prime Minister had gone to United Nations with this issue about Kashmir, and they had passed a resolution, and they had said you should have a plebiscite. That resolution is still there. Thanks, Lord, nobody is now after that United Nations resolution. It's for that reason that it had been called temporary. That's the only reason. Now, my lord, I'm seeking your lordship's permission, first of all, to refer to a scholar, A.G. Nurani. I know him personally. He had taken the permission from the Prime Minister to go into the archives and take out the documents which were confidential. And then he, my lord, wrote this book. It was not out of imagination or out of some sources like me and others or some politicians. It was with the sanction of the government of India that he had access to these arguments with my lord. Now, I first of all, my lord, even if your lordship have volume 20 books -F, I'll be reading from that.
Volume
I think your lordship have that. Volume 20 books -F.
What PDF page will that be?
It says, my lord, article.
Yes, you got that. It's at page 1, volume 20. That's Mr. Nurani's book.
Yes. Article 370 of the Constitution of India relating to the state of Jammu and Kashmir, Jammu is missing, is now, that time it was 60 years old, now it is much longer. The Constitution came into force on 26th of January 1950, which our children celebrate every year, this 26th of and 15th of August. 26th of January 1950, and with it, this unique provision. All other provisions were debated in the Constituent Assembly of India after deliberations in its drafting committee and sometimes discussions in the Congress Parliamentary Party. Article 370 was discussed for 5 months by the Prime Minister of India, Jawaharlal Nehru, and his colleagues with the Prime Minister of Jammu and Kashmir, Sheikh Mohammed Abdullah, and his colleagues from May to October 1949, and then the reference is there. The state of Jammu and Kashmir is the only state in the Union of India which, my lord, negotiated the terms of its membership with the Union. The reason for that was Mr. Jawaharlal Nehru's Security Council resolution which said that status quo should be maintained till they decide which party is right. The Constituent Assembly merely put the imprimatur of its approval on 17th October 1949 to a draft agreed between the Union and the state. Article 370 records a solemn compact. Neither side can amend or abrogate it unilaterally except in accordance with the terms of that provision. The Union Home Minister, your Lordship may forget that, and move on to the next one on page 2. A little over a decade after, it is the second paragraph, a little over a decade after the enactment of Article 370, its co-architect, Prime Minister Nehru, declared in the Lok Sabha on 27th of November 1963 that Article 370, within quotes, has been eroded, if I may use the word. And many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. And that integration was not only constitutional, it was also emotional. It was also based on certain principles. Kashmiris rejected the idea of Pakistan. Some fresh steps are being taken, and in the next month or two, they will be completed. We should allow it to go on. What had happened in the next couple of months, Sheikh Abdullah was arrested. We do not want to take the initiative in this matter and completely put an end to Article 370. That was in his mind that in some form or the other, it should stay there, maybe for emotional reasons. There was no need for that, as the Union Home Minister Gulzari Lal Nanda explained in the Lok Sabha on 4th of December 1964. The only way of taking the Constitution of India into Jammu and Kashmir is through the application of Article 370. It is a tunnel. It is through this tunnel that a good deal of traffic has been passed. It is a one-way tunnel, and we are not unhappy with that. He pointed out that while the normal process of constitutional amendment is subject to stringent conditions, the process of amendment made available under Article 370 is very simple. It's a pragmatic approach. Why to have a constitutional amendment from time to time? If you can pass an executive order through 70, why not resort to this? Sorry, sir. In regard to the rest of India, if a state's power are to be curbed and correspondingly those of the Union and law, the elaborate procedure laid down in Article 368 will have to be followed. In regard to the state of Jammu and Kashmir, Nanda argued a mere executive order made by the president under Article 370 would suffice. His successors in office accepted this interpretation of Article 370. Except, my lord, as your lordship will see, that is a tunnel. It is a tunnel, all right.
It appears
But
that Mr. Nurani's thesis is substantially in terms of what Mr. Dwivedi argued. Because Mr. Nurani also
He
says
did
that
not
once
have
the
the benefit.
Constituent Assembly of J&K was dissolved and the Constitution was framed, then Article 370 came to an end. And then everything he says that happened thereafter is unconstitutional.
Yes, my lord, I endorse that, madam. Nanda concluded what happens is that only the shell is there. Article 370, whether you keep it or not, has been completely emptied of its contents. Nothing has been left in it. Now, your lordship may kindly turn to is it page 3 and para 2. The Indian Independence Act empowered the Governor General of India to adopt the Government of India Act 1935 as the interim constitution till the enactment of a constitution by the Constituent Assembly of the state. That act, as adopted, served as a constitution from 15th of August 1947 to 25th of January 1950, my lord. Then, my lord, the last 5 lines of this page, the Governor General had written a letter, stipulated that as soon as law and order have been restored in Kashmir and her soil cleared of the invader. No, some years back, those invaders came, my lord, as not just invaders, but as militants, but as terrorists. The government of India made it clear that they would regard it as a provisional until such time as the will
Mr.
of
Baker,
the people of the state.
What is the drift of what you're arguing? I mean, what is your contention? What is your submission?
My submission, my lord, is finally this, that when all these documents and orders are studied, the abrogation of the state assembly, the abrogation of all its institutions, abrogation of Article 370 is unconstitutional, unnecessary. It's just a political gimmick. That is, my lord, the pith and substance of my argument. Then, my lord, clause 7 of the instrument of accession will show that in the beginning, our accession was on one extreme. And now it has gone from the one extreme to another extreme. In the beginning, my lord, according to the white paper on Jammu and Kashmir, published by the government of India early in 1956, recorded in accepting the accession, the government of India made it clear that they would regard it as purely provisional until such time as the will of the people of the state could be ascertained. Lord, then I might, Lord, go to the next page, the second para. The state had acceded to India 1947 in respect of only of defense, foreign affairs, and communications. Negotiations were held on 15th and 16th of May 49 at the Deputy Prime Minister Vallabhbhai Patel's residence in New Delhi on Kashmir's future setup. Nehru and Abdullah were present. Foremost among the topics were the framing of constitution for the state and the subjects in respect of which the state should accede to the Union of India. On the first, Nehru recorded in a letter to Abdullah on 18th May that both Patel and he agreed that it was a
Possible to formulate, because you formulated it in your submissions, instead of really reading us through Mr. Nurani's book. We'll certainly look at Mr. Nurani, the book, and all the other material which has been given to us. If you could just formulate now your points really, because a lot of this ground has been covered by the council preceding you.
yes, my lord. Okay.
Almost
My lord,
everything
we
has
have
been
the
covered.
written submissions, but anyway, I think since my lord want to go to the bottom of it, but in a very short, my lord. पेज है इनके पास
In fact, we made a request.
No paper, please. Yes. Give
My
it
lord,
paper.
before I go to this, my lord, the written submissions, I have also written submissions. In this issue arose for the first time in Supreme Court of India in 1982. In a presidential reference, my lord. There was a dispute in the Legislative Assembly of Jammu and Kashmir, which was also its constituent assembly. A dispute arose whether Article 370 should be changed or modified. That was the issue. My lord, it went to the Supreme Court. At that time, my lord, I was vice chairman of a political party, and I submitted, my lord, a written note. It is here, my lord, I'll pass it on. In this, my lord, if your lordship see that after the lordships heard us, the simple order was, we don't think it necessary to intervene in this matter. And that's how it stood. That's why nobody, my lord, was bothered about it. After about every month and every 2 months, one entry or the other was, my lord, brought through Article 370 into Jammu and Kashmir. And when Sheikh Abdullah objected to it, my lord, he was sent to prison for 19 years. And his deputy, Bakshi Ghulam Ahmad, was taken into confidence. When he stopped playing the game, he was removed. And Ghulam Ahmad Sadiq was made the chief minister, maybe without majority. No, my lord, this is a tragic story. And finally, it has landed here in this August House. Got a final say. If this article, as some people have said, my lord, that this article is useless, but there is something more than bread and butter for human beings, whether they are people from Jammu and Kashmir, Jammu or Kashmir or Ladakh. They have, my lord, they were born with the idea that somehow we will be protected, we have special rights under 370. Article 3 was amended by the impugned legislation, and totally contrary to the provisions of Article 370, Ladakh, Jammu and Kashmir was broken into 3 parts. Governor was replaced by Lieutenant Governor, who is a gentleman of the highest order. There's no doubt about that. But how can 370 be abrogated. What was the mechanism? First, ask the governor to dissolve the Legislative Assembly of Jammu and Kashmir. For what reason? Nobody knows. He just passed the order at around 12 o'clock at night. The certain orders were then issued by him. After some time, he was transferred without any reason and sent to a God-forsaken place. And what he said thereafter, I didn't bring it on record. This is step 2. What is step 3? You pass an order by virtue of which the Constitution of Jammu and Kashmir is abrogated. And you pass that order under Article 370. After that, what's the next step? You abrogate Article 370. Now, I'll pass on the documents to my lord if your lordship are pleased to, all the documents which are by my lord necessary. If I really go into details, my lord, I will take more time than my class fellow, Mr. Kapil Sipal, had taken. But since your lordship have set a deadline, I must accept the humility and say that thank you very much.
Thank you so much. Thank you. Thank you, Mr. Dey. Thank you very much.
On record.
Thank you, Mr. Dey. Thank you, Mr. Dey. Mr. Shankar Narayan, what will we dive in?
If cannot be, permit me.
You're now the final counsel on your side. We'll give you half an hour from 2 to 2:30.
My lord have information to place on record.
Why don't just Mr. Shankar Narayan just tell the nodal council to circulate what Mr. Beg gave.
My
Just
lord, it was
circulate it in the
given
form
to
of.
the earlier advocate.
No
of the
difficulty.
government, but
No, we have a nodal council who will scan it and just make sure that it's on our record.
These orders from my lord.
No difficulty. Naturally. So, Mr. Shankar Narayan, we'll hear you 2 to 2:30, but precise, I know you'll be able to do it in half an hour and then. Yes. You want the temperature to be increased a little?
Yeah. Lord, every one of us, Lord, it's very chilly.
All right,
It's very chilly. The warmth of the
my
argument.
lord, their attendance may be recorded.
Certainly, certainly,
Their
of course.
presence may not be.
We'll be back at 2 o'clock. Thank you, Mr. Beg.